All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in 1 CACV 170206, GODOY versus WEIR. Counsel, each side, as you know, is allotted 20 minutes for argument. The appellant may reserve a portion of that time for rebuttal. If you wish to do that, so sir, you're going to need to keep track of the time using the podium clock. Out of respect for the court and counsel, I ask that those in attendance please make sure your cell phones are off or on vibrate. Counsel, we have read and reread your briefs, and we've conferenced the case just this morning. We encourage you to keep that in mind as you present your arguments today. The proceedings are being recorded and will be posted to YouTube. Before you begin your argument, please state your name and the party you're representing. With that, we will start with you, Mr. Taylor.
May it please the court. My name is Neil Taylor, and I represent the appellant, Garrett GODOY. I want to thank you for inviting us to be here today. And the first thing I would say is you must have had some questions, so I would ask the panel, are there any questions that you would like me to address in my remarks?
All right, I'll start off with my concern is the use of the term custodial parent in Section 6C. As a former Superior Court judge on the family court bench, that term, custodial parent, meant to me basically primary residential parent, somebody that has the children 50% plus 1 day. And I know that's not defined in Section 6 or 6C, but it is defined in 9B1, and it says just that. Custodial parent is a parent who has the physical custody of the children for the greater part of the year. In an equal physical custody situation, which I believe we have here with your client's other children, neither parent shall be entitled to the credit for purposes of calculating child support. Isn't custodial parent that very definition that I just read in 9B, I'm sorry?
Thank you, Judge Bean. I think what you have to do, you cannot look at one provision in isolation. And this has been our position from the get-go. The adjustments pursuant to Section 6, in this case we're debating whether 6B or 6C was the proper tool to be used. You have to hearken back to the overarching mandate of ARS Section 25-320D and also to the purposes of the guidelines. If a mechanical application of the guidelines does not or violates or vitiates that overarching purpose and the specific 8 factors listed in 25-320D, then you've chosen the wrong guideline. And let me give the court an example on that. When the court, and this was a case from 1992, the guidelines were somewhat new in operation. It's a case out of Division 2 of the Court of Appeals, the Gallegos case at 174 Arizona 18. In that case, and it's not a case I cited in my brief because I didn't really see that as an argument and it applied to another issue. But in that case, let me just go through the facts briefly to highlight how the Court of Appeals says you must always hearken back to the purposes of the guidelines. In that case, it was a divorce, 1989. There were 3 children. Child support of $400 was ordered. And
Is it a pre-guideline case?
No, it's a guideline case. It's a guideline case. And in March of 1989, it was increased to $450. In May of 1989, father sustained a severe injury, C5. He was paralyzed on down, from the neck on down. Because of that, he received a large settlement, approximately $2 million. Now, after he received that settlement, mother moved to modified child support. And the trial court did a pure mathematical calculation of child support. They followed the guidelines to the letter, all right? And they said the trial court then made a finding the father's income was now $9,894 and mother's income was $737, and that the computation that resulted was father would now pay child support of $2,232. Now, there the court said that the trial court abused its discretion by awarding child support based solely on the schedule and a strict application of the guidelines, and that it was inappropriate and unjust because it violates the statutory provisions from which they were enacted. And that's what we have here. And I would say the court has an option, 6B, 6C. If you choose one of the tools and you end up violating the purposes of the guidelines, or you end up vitiating those 8 factors set forth in 25320D, you've got the wrong tool. You're choosing a hammer.
So, are you agreeing, and if you're not, that's fine, but are you agreeing then that under a strict reading of the guidelines, your client loses, and then you're asking us to disregard that because it doesn't comport with the statute? Is that your position?
Our position is that custodial, taken in this sense, means a person who has custody, which he does have custody. He has custody of the 4 boys.
But counsel, custody means decision-making authority, not custody in terms of parenting time. I think you're conflating those two.
He has physical custody 50% of the time. He has custody as defined by various statutes.
But counsel, you would agree with me that custody is no longer, custody has been replaced, I think it was in 2011 or 12, with legal decision-making authority. And I think that's where a lot of this problem lies, is that in C, and I'm not faulting you, you didn't draft this, about custodial parent. And like I said, and I don't think you really, counsel, really answered my question, custodial parent, as I understood it as a trial court judge, was somebody that had 50% plus 1 day. Would you agree with me that's how it's practiced in family court?
I've seen it practiced different ways by different judges. And I think that's part of the reason why you have a problem here. And if I can go back to it, if you look at Section 6B, 6B was part of the another paradigm. Because in the 5, 10, 15 years ago, the paradigm was you had a single custodial parent who had most of the time, you had a non-custodial parent who had every other weekend and maybe a Wednesday, and that's what 6B was intended for. And when you look at the guidelines as they march through time, that provision was in there initially. The provision that is now Section 6C wasn't in there. What there was an amalgamation of the language of 6C and 6D, which made it discretionary for the trial court. And it
but
wasn't.
6C is not discretionary.
No, 6C is not discretionary now. And I think that was in 2000 or maybe 2004 when that was made not discretionary, mandatory.
Is there any way to get there under 6D?
Well, if father had not married, and if he had those children outside of wedlock, and there wasn't an order, then you would be exactly at 6D. And that's the irony of it. In using the calculation the way it was, he would be entitled to it. Not entitled to it, it's discretionary with the court.
But since he is married, D doesn't get you where you need to go.
No. And going back to the argument of the choice of 6B defeats and it vitiates the overarching purposes of the guidelines and the factors articulated in 25320D. In that, and if I may, I just want the court to think about a couple of the factors. Okay, we talked about in my brief, and I'm not going to argue again what we already talked about in the brief, and of those factors that the court should consider the financial resources of the parents, et cetera. But the one factor that really wasn't expanded on, although Mother talked about it a little bit more than I did, but I think really should be expanded on, is the standard, and that's 25320D3. the standard of living the child would have enjoyed if the child had lived in an intact home with both parents. That's the income shares model. It's basically a restatement of that. And under the income shares model, the total child support amount approximates the amount that would have been spent on the child if the parents and children were living together. Well, we had that. When this child was born, Kayla was born, she was living with father and with mother, but that wasn't the whole household. There was also his 4 other boys. Elijah, a teenager, Xavier, a teenager, Gavin, who's now a teenager, and Mason. There was a household of 5 children, and the resources that father could devote to the 2-year-old or the 1-year-old were going to be diluted by his also devoting resources to the other 4 children. And the record indicates this was not just, an absentee father, and we cited to this in our record. These children, these teenagers were involved in other kinds of activities, extracurricular activities, and as the court can take judicial notice of, those are things that cost him money. It dilutes his resources. And
Counsel, I'm still trying to get a handle, at least legally speaking, what your argument is. Are you arguing that under 6C that we should apply a broader definition of custodial parent than what we have in 9B1? Or are you conceding that that definition applies and we have to disregard the guidelines because they don't comport with the statute?
That's exactly what I'm saying. The former position, Judge Howe, that the court has to be guided by the purposes of the guideline, not by the specific language. And that was why I talked about the Gallegos case, because they did it exactly the way it was.
So you're conceding, for purposes of the argument, that custodial parent in 6C is the same as in 9B1. I'm not forcing you to do that. If you think that I think there's an argument to be made that the definition in 9B1 is specific to 9, and it shouldn't apply to 6, but that doesn't seem to be what you're arguing.
No, but I would say that is what I would be arguing, and I should be arguing. Because otherwise you end up with no custodial parent, and then what's the purpose you have? And this is what I said. The position taken by mother was basically that the father is in a like a legal bardo. I mean, they're not custodial parent, they're not a non-custodial parent. I mean, that's unreasonable.
Well,
Doesn't that happen all the time when you have a 5225 parenting time? That no one's a custodial parent, you share equal time?
You share equal time, exactly, but still you would get the credit. And this has been my experience in the trial court. You will get credit most of the time. You'll get credit and an adjustment. And in fact, this is exactly the position that mother had not taken this position until the trial judge said, "Oh, we're going to apply 6B." When you look through the and I'll refer the court to the pretrial statement of mother. In her pretrial statement, she was in 100% agreement with us. She said, yes, father is entitled to an adjustment for his 4 boys. And then the amount, she cited the amount was, from the tables, which we were in agreement. That's our position. And it wasn't until the trial court went off on 6B that mother then reversed her position and said, well, no, we're going to go ahead and follow mother's. This was not an issue that was really briefed, and it wasn't a main issue of contention because we were both of the same mind that he was entitled to an adjustment for those 4 boys. And I think the court cannot ignore the end result. The end result, if you apply 6B, is 0. And that flies in the face of equity and the guidelines and the purposes the factors set forth in 320D, because you say he's entitled to no credit, even though we know that he has that obligation and that drain of resources. But we're going to do a technical reading and say, since he doesn't pay child support, it's 0. 4 boys, 3 of them teenagers now, no credit, no adjustment. And then going back to Judge Catani's question, well, if they hadn't been married, well, do you think that you could have? Or I think I misstated. But the question is, if he had not been married and if there hadn't been an order, yes, he would be at least entitled to an adjustment under 6D, because there it's discretionary. What would have the trial court done? I don't know. Then if the trial court had chosen not to do it, maybe there would be a different argument involved.
If it's 0, does that translate to no order? Or you're suggesting that D simply does not apply?
I'm saying, well, I don't think D does apply. I think that C applies, Judge. And there is no order. So that's another reason why, if you want to be literal about it, there is no order. That's why B wouldn't apply, because there is no order.
Do you have any other authority than the case that you discussed a few minutes ago about our authority to disregard the guidelines?
Well, and I don't want to misstate it. In that case, the Gallegos case, they didn't disregard the guidelines. What they said was that the trial court didn't follow the spirit of it. They did just a mechanical application of the guidelines, and in so doing, they violated the overarching purposes. And in that case, they didn't appropriately consider the needs of the children and also the needs of the non-custodial parent. Because in that case, the non-custodial parent, the father, although he had a substantial income, technically, he also had large expenses that he had to pay, about $6,000 just every month to maintain himself. And the trial court said, the Court of Appeals said, well, they didn't consider those. They just strictly went by the book and by the application. That may have been okay, but they're not considering the statutory provisions from which they were enacted. That's their language.
Well, it seems like if we apply the guidelines as they're written, as the trial court did, then the trial court was correct. It seems like the only way that you succeed is to say that the guidelines are inconsistent with the statute and we're bound to follow the statute instead. Is that what your argument is?
Yes. Yes, Judge Howe.
And your argument, I think, Mr. Taylor, you said relies on 25320D3. Is that correct? Is that how?
No. I just wanted to expand on that. We actually cited in our brief a number of those factors. D3 I mentioned, but I didn't expand on it, and I think that that's an additional factor to expand on in addition to father's resources.
So tell me, what did you raise below that you preserved for us to make the ruling you want us to make today?
We argued that it was violation of the factors set forth in 25320D and the purposes and the premises of the guidelines, and that the result that came vitiated the overarching directives, the mandate of 25320D.
Thank you, counsel. And would you give me that Gallegos site again? I think I missed it.
Yes, it's 174 Arizona 18. It's a Division II case, 1992.
Thank you.
With that, I'll reserve my remaining time.
Thank you, Mr.
Thank you.
Taylor. Mr. Hanson?
Thank you, Your Honor. May it please the court. Again, I would echo the remarks of my colleague in thanking you for giving us the opportunity to answer any questions that you have, etc. on this. I want to address First, the Gallego case, obviously it wasn't cited in the brief, so I haven't been able to take a look at it or address it. But based on Mr. Taylor's description of the holding of it and looking at 25320D, I think what I'd state is it sounds like the holding of that case was the trial court had abused their discretion by mechanically applying just the sheer mathematical formula rather than looking at all the circumstances. And I would point to D as there is a mechanism there for the trial court to look at the total picture, so to speak, and make a discretionary finding that's the deviation. The trial court can find a deviation if it finds, as it says in 320D, that application of the guidelines would be inappropriate or unjust in a particular case. That's the case for deviation. That is sort of the pressure release here.
Well, why doesn't this case fit that, where there's no question that it costs money to support 4 kids? The money is being spent, but father's getting 0 credit for that.
Well, I think there's a couple reasons for that. One, looking at the child support order for the 4 children, okay? Father is getting credit under the guidelines for the time the kids spend in his care and for his financial contribution. That's included in the guideline calculation as far as an equal time split. Additionally, they deviated from the child support that was originally ordered in 2012, and if I did the calculation based on his current income, it would be closer to like $300, but they already did a downward deviation based on the circumstances of raising 4 boys and so forth. They already did it. The court made findings, and the parties asked for a deviation in that case. So father's getting credit for the 4 boys in the original calculation. What I don't want to see happen is if we apply C, as Mr. Taylor is arguing for, one, I can certainly see a situation where, let's say, father ends up back in court on a modification of the first case, child support's awarded, because as I said, if I run the calculation based on the income the court found in this case for father and use the old numbers from the worksheet other than increase his income, he could end up even on an equal time shared parenting plan with a $300 child support order. We can certainly see a situation in which I pointed out in the brief where father then gets a double dip. Why shouldn't he get credit under B for the $300 he pays, and also, pursuant to Mr. Taylor's argument, also get credit under C for almost $2,000? It lowers the base child support amount for all 5 kids at that point, because he could do the same thing in the original order. Now that I'm paying, if I have to pay this for this, you can see how that, the only one that benefits out of that is father, because it lowers the base amount of child support for all 5 children. And
isn't that consistent with the overarching principles of treating the kids the same way they would be if there were not a divorce?
Yes and no. I think the overall, I would disagree with Mr. Taylor on his characterization of what the overarching principle is for the guidelines and for 320. I think the idea is, and I'll agree with him, it's the income share model. If the kids were all living in the same household with the parents, what would the combined income, what would they be spending on them? But it's also to make consistent and make sure the children's needs are being reasonably met. The child support, the children and what their reasonable needs, and that's what base support is based on, and then we do adjustments to increase that based on, extra medical expenses, extraordinary expenses, the medical insurance costs, child care costs that we add on to that to get the adjusted number. I think child support in general, the paramount is really we need to be supporting these children and make sure that they're getting adequate support across the board. I don't see how in allowing father to take basically possibly double dip or quadruple dip or whatever, taking these, and they're fairly significant deductions, especially when we're talking about C, taking those.
But you would agree if he had not been married and he were just.
But then it's discretionary.
The first one.
I would agree he might qualify under D, but that D is discretionary, which means the trial court can basically shape it, model it to the circumstances that it finds.
And I apologize for interrupting, and this may be clear from your briefing. When you say he's already gotten credit for the 4 kids, where has he gotten credit for the 4 kids? And I may be misstating what you said.
He's already getting credit for the time the children are spending in his care, because even when we're doing equal time, but let's say it was unequal time and he was under the old terminology, the non-custodial parent, he'd get credit. Non-custodial parents get credit for the parenting time days they have. They get that parenting time credit. In equal time, they get a certain credit also for that, but it's based on each parent getting sort of the same amount of credit, which is why they just look at the difference eventually in income after giving each parent that sort of across-the-board credit. So he's getting somewhat the credit for the children being in his care.
If he had no other children, what would the amount have been
For
your client? What would the figures have been?
I think that because he didn't get the credit for the 4 other children, I think the amount was something like $12 or something, if I recall, from the trial court's minute entry, which the trial court then said was de minimis and deviated to
That's
0.
assuming he has no other children, he's not taking care of them in his home. You're saying the amount would be $12?
Something like that, based on the incomes.
And he didn't receive any credit for his other children, so what Judge Harris came up with, and I think it's $19.60,
right,
$19.60 a month was what?
It was a very small amount, yes. So what Judge Harris came up with for the order was basically not as if he didn't have 4 other children. But realize, if he had been paying support for those 4 other children, he would have gotten credit under B. Judge Harris was very clear about that.
But that's what seems odd. Let's say those kids were living full-time with their mother. He gets credit for everything. He's supporting them there, but he doesn't get any credit for actually providing care for them in his own home.
Well, he'd get credit for, let's say it wasn't a 50-50 split. Let's say it was 51-49 or whatever. He'd get credit for whatever 49% of that time was, because you do the table and say, I don't remember what almost halfway is, let's say 290 days. He'd get an actual credit for that, a number, which would probably be close to equivalent of what, it'd probably be well over $1,000 for that time in the original child support order for the 4 children. What he's trying to do is, and he's getting some sort of equivalent credit for the 50% of the time he has now. It's just, it isn't as clear based on the calculator. But it is clear that he's getting a credit for the time the children are spending in his care. And he also got a credit because they deviated in that original case where he would have been, under the guidelines, been paying child support, they deviated to 0. So if they hadn't,
and that's why you're saying he's getting a credit for these 4 children.
Right.
It's not in this case. It's with his first.
Correct. In the first case, he's getting a credit there. If they hadn't deviated down, and he was paying some support, and as I said, if you did the calculation now of what the income that Judge Harrod found and applied it to that first case, he'd be paying $300 a month. He'd get credit for the $300 a month that he's paying. Judge Harris was very clear in our case. He'd get a credit under B.
Would you agree with me, Mr. Hanson, that in C, when the term used custodial parent, in practice, custodial parent is carried out in practice in the family court setting just as it's defined in 9B.
Yes.
Okay.
And speaking to that, as I cited in my brief, and I'm not going to, you guys just read it this morning, so I'm not going to bore you with recitation of it, but as I cited in the brief, the case law is pretty clear in applying the guidelines or applying the same rules of statutory interpretation this court applies, which is we look at the plain language. If we can't figure it out definitively from the plain language, then we look at it in the context of the statute or of the guideline here, the guidelines.
Why define it, though, in 9B and not earlier? Doesn't that suggest that I could read it, if I'm reading it without 9B, I would simply say, okay, let's say it's 30% custody, you just provide,
But I don't,
accurate as 30% versus 70%. And 9B seems to have a specific purpose in terms of the federal tax credit, where it necessarily has to be one or the other gets the tax credits.
but it's not only used, that terminology of custodial and non-custodial parent isn't only used in 9B. It's also used, as I cited, in the statutes surrounding the equal time, shared time, in Section 11. It's also in Section 14. It's conspicuously absent from 12.
But the only definition of custodial parent that I'm aware of is in 9B.
Right.
That seems an odd placement for a definition that applies, as you argue, across the board to all the guidelines.
But it does, I understand the court's position that normally I would expect to see a definition like that in probably Section 1 or 2 in the beginning, but it still comes before the Section 12, which defines the equal shared parenting time. And there is no mention of custodial or non-custodial in that. And I think considering in the provision before it in 11 and in 9B, and in the provision after in 14, although it's defined in 9B, the use of the same terms are used in the same way in Section 11 and Section 14 to designate basically the custodial parent being the person who has, as Judge Bean said, 50% in one day, or the majority of the actual physical custody and care of the child or children. That seems to be the definition that the Supreme Court is using when they're promulgating these guidelines throughout the guidelines. When it's used, that's used in that way under those provisions. It's specifically not used, and it says, I think in 11, that, or it might be 14, that it specifically does not apply to equal parenting time arrangements, and that you're referred to subsection 12 in dealing with those. In subsection 12, there is no mention of custodial, non-custodial, or anything to that effect. As I've cited in my brief, our case law and precedent in doing this construction is also very clear that if it's been excluded, and I cited the Meade case for this, where they were dealing with different, using disability benefits as gross income to be imputed, the court specifically said, look, if it's not in there and it's excluded, we're not going to insert it in. If it's excluded, it was excluded for a reason, and we have to read it that way. Again, it's not in 12, which deals specifically with this equal time, shared parenting time arrangement. It's not in there, and it must not be in there for a purpose, is how the precedent states how we're supposed to treat that. And that would be how I would ask this court to treat that the same way. What it appears that they're really arguing for is they wish they had argued for a deviation at the trial level, which they didn't. They argue just for application of 6C. I think if they would have argued for a deviation, I think that possibly, since they didn't qualify for 6D, and if there would have been a concern about the extracurricular activities for the 4 boys, etc., that would have been factors to be considered under D, one of many factors to be considered under D, and these factors are not exclusive either. The court's given pretty wide discretion on how to weigh them, what weight and sufficiency to give them, and also to include anything else.
Are you saying it has to be the extracurricular activities? Is there a deviation just based on the fact that I'm caring for four teenagers in my house?
It could be, just on that fact, and 4 teenage boys eat a lot. I think you probably take judicial notice of that. And probably eat more than non-teenage boys. But, that could have been a factor for the court if they had asked for a deviation. They didn't ask for a deviation here. They asked for a full credit under C. And our position is that is not how I think the guidelines are intended to be applied here. It's intended, especially with the clear language in C on the custodial parent, that we're trying to give relief to the person that has physical custody and care of the children for a majority of the time, the 50+1, or has it 75% of the time. Something that we saw more of a paradigm, as Mr. Taylor said, maybe a decade ago than we're seeing now.
Why would we want a bright line rule that at 51% or 50+1, you get credit, at 50, you get 0 credit? That doesn't make a lot of sense to me.
Well, otherwise, I think what you're looking at is why would we want to give him a double credit? Let's say he was paying child support for equal time, and we now consider him the custodial parent. Both B and C are mandatory. So if that's the case, let's say he was not paying 0 in the first case, he was paying $300. So would we be mandated to give him credit not only for the $300 he's paying in child support, but then another $1,900 as the custodial parent?
Well, so if he has custody 1 day more, then he's not double dipping, and
Right.
Because if it's 50, then he is double dipping?
Correct, because if he's got custody 1 day more, then we're going to a different section of the guidelines, and we're doing a different calculation, and he's not. If you are the custodial parent pursuant to the guidelines, you're not paying child support. You're presumed to be supporting the kids with whatever funds, your share of the funds. Only the non-custodial parent, the one who doesn't have the 50+1 time, is the one obligated to pay the support.
I'm just puzzled, though, by your use of the term double dipping. If it is, there's no double dipping if he has his other kids 50%+1.
No, because then he'd get credit under C, but he wouldn't get credit under B because he'd be the custodial parent, and you don't get credit under, you don't have an obligation to pay child support if you're the 50+1.
There's no circumstance under which you would still be obligated to pay some child support?
No.
His income is significantly higher than?
No, because the non-custodial parent, the one who has less time with the children, is the only one obligated to pay, and I think that's under 11. Oh, forgive me, it's under 14. So the non-custodial parent is the only one obligated to pay child support. The custodial parent isn't. So anytime we're at 50+1 or above that, the custodial parent is never going to be the one paying child support. It's always going to be the non-custodial parent. It's only when we get into this question of does 50-50 time equal custodial parent where possibly both B and C would apply. And that seems fundamentally unfair, and I would argue is not within the spirit and intent of the guidelines or 320. Thank you.
Thank you, Mr. Hanson.
I think I have just about a minute left.
Let me ask you, let me start that minute 53 with, I have reviewed the briefs and the record, but I can't remember, and you can refresh my recollection. Did you argue for a deviation at the trial level, Mr. Taylor?
No, we did not.
Then, so what are we supposed to, we're wedded just to the record? If you didn't argue it below, then how can we get you your relief?
Well, our argument has been that Section 6C, which was the position that Mother took throughout the litigation, is the adjustment that should apply. That has been our position.
But not throughout the entire litigation. At some point, she changes her position. At that point,
Yes,
you
that's
could, in
correct. She
theory,
did.
ask for a deviation.
No, we didn't ask for a deviation. And
So nowhere in the record did you ever ask Judge Herod for a deviation?
no,
Okay.
I wish we had, but we did not.
Go ahead, thank you.
And I didn't want to mislead the court. In the Gallegos case, apparently they had asked for a deviation in that case, and that was why it was an abuse of discretion, because the court did not deviate downward. But still, they hearkened back to the overarching principles. And coming back, I know Judge Kutani asked the question, well, how much of an adjustment then would he have got if there was no children? And counsel kind of hesitated, but the answer was the same. 0 children, the same, no adjustment. This idea, I have to say, this idea of double dipping, first of all, I don't see a trial court doing that, applying both B and C. I think it's a one or another. The other thing that I really objected to was counsel saying, well, father could get an adjustment of $300 because he's presuming that the mother in the other case doesn't also have an increase. I thought that was inappropriate. I think we have to stick by the record in that. And the adjustment was $80 that they deviated down, and we can't really go into the reasons why they deviated down.
Thank you, Mr. Taylor.
Thank you.
I want to thank you both for your willingness to come back and enlighten us on this very kind of interesting issue that we found during our review of the briefs and the record. So I thank you for your briefs, and your presentation here today has been very helpful. We will take the matter under advisement, and we will issue a written ruling in due course. The court now stands adjourned. Thank you.